Hi, my name is Rob Berry. I'm a partner at O'Connor Dissing, and I'm pleased to welcome you to the team. At O'Connor Dissing, we strive to ensure all solicitors receive the utmost quality of training so that our clients receive consistent and market-leading representation. As part of our training module series, today we will consider the issue of concurrent conflicts within a firm and the potential for conflicts of interest. This will be explained through myself and other lawyers at O'Connor Dissing, who will discuss the issue in light of a theoretical concurrent scenario that could arise at the firm. By the end of this module, you should have a detailed understanding of the theoretical scenario and its arising issues, relevant law that would apply, and the ethical frameworks that we can use to mitigate these ethical issues. We will also discuss the most optimal way to resolve the issues that would arise. Now I'm going to explain the theoretical scenario of a concurrent conflict. There are two co-accused, Lily and Phil, who come to the O'Connor Dissing team. They have both been charged in the armed robbery of a young lady in front of a luxury store in Bondi. They were charged as co-accused, and the Crown is proceeding with a joint trial. O'Connor Dissing committed to representing both Lily and Phil because they had perfectly aligned testimonies and both pleaded not guilty. Two solicitors from our criminal law team were put on the case. One was Susan, whom we made the first point of contact for Lily, and the other was Alex, who was the same for Phil. As there was absolutely no conflict between the clients' cases at that point, Susan and Alex were in complete and transparent communication with each other. Both Lily and Phil were on bail prior to the trial and regularly attended our offices together. After a few weeks of pre-trial preparation, Lily called Susan and said she was actually under the duress of Phil at the time of the robbery. Susan knew that Lily should pursue a cutthroat defense against Phil involving the provision of evidence which would exonerate Lily at Phil's expense. Lily asked Susan what she should do and pleaded with Susan to not tell Alex or Phil about what they had discussed. Susan then found herself in a position of conflict and did not know whether she should disclose this information to Alex and Phil. After consideration, Susan eventually let Alex know that potentially conflicting evidence had come up and that she had set up a Chinese wall using the firm's software to separate the cases. Alex then told Phil that the cases were going to be run separately from now on and that there was a potential conflict otherwise. Phil fully consented to this. However, he did not know the details of the conflict. After that point, Phil and Lily attended the offices at strictly different times. A little further down the line, one of the partners became aware that the co-accused were no longer running accompanying testimonies and instructed Susan and Alex that a conflict had arisen despite the construction of the Chinese wall. Phil was advised by the firm to seek alternate legal advice. He was refunded the full amount owed for payable hours accrued after we became aware of the conflict, and his retainer was also formally terminated. Despite this, Alex called Phil and wished him the best of luck, apologizing for what went down. He gave Phil some advice on alternative firms he recommended and possible arguments he could run in court under his new representation. After the call, Phil was left with the impression that he could still contact Alex for legal advice on the case.
Hi, my name is Lockie and I'm a solicitor at the O'Connor Dissing team. We will run over some of the basic legal principles with you today that could apply to this ethical issue. Thank you to Rob Berry for succinctly explaining the theoretical scenario. All legislation that will be discussed in respect of this ethical concern is situated in the Australian Solicitors Conduct Rules 2015 under the Legal Profession Uniform Law. In order to promote a relationship of trust and confidence, all lawyers are obliged to act for the client's best interests. This takes form in a fiduciary duty owed by all solicitors to their clients. This is not to be taken lightly. When an issue of concurrent conflicts comes up, the Solicitors Rule 11.1 provides that a solicitor and a law practice must avoid conflicts between the duties owed to two or more current clients. Further, under Rule 11.2, if this issue arises where a solicitor is not able to act in the best interest of their client, they must not act. Or we have Rule 12.1, where a solicitor must not act if there is a conflict between their duty and the client's best interests. Rule 12.1 also states that an individual lawyer cannot avoid a conflict by giving the case to another person in the lawyer's firm or a person not entirely independent of the lawyer taking on the matter in the prescription against associates. The duty of loyalty seeks to ensure the client is entitled to place their trust in the solicitor or law practice, and that the client is confident that the lawyer will not take advantage of their self-interest. This ties into one of the main sources of loyalty which solicitors have, which is the retainer. The retainer is generally treated as a legal contract for solicitors as it sets out the terms and conditions of legal services to be provided. However, once a solicitor's retainer has ceased, this is when there is no lasting duty of loyalty to the client and conflicts of interests would not otherwise arise. This is relevant to the facts at hand as it begs the question of when Phil's retainer ended. The formal termination of the retainer does not always conclude fiduciary loyalties. As the court said in Marcolongo v. Mattiusi, prudent lawyers should err on the side of caution in regards to conflicts even when a retainer is terminated, particularly where the client perceives that a lawyer-client relationship persists. A client can consent to a conflict of interest, thereby avoiding a breach of fiduciary duty. As the court said in the Law Society of New South Wales v. Harvey, the disclosure must be conscientious, detail everything known to the lawyer relating to the conflict, and that the client must be advised to seek advice from a third party to be prudent. Here we know that this would have ultimately been impossible. While Alex made Phil aware of the conflict, it was not a disclosure of all the material circumstances, just a disclosure of the fact that a conflict had arisen.
Hi, my name is Emma and I am a solicitor at O'Connor Dissing. Now that we know the basic legal principles that govern this ethical issue, what are the next steps that we as lawyers should take? It is important to remember when considering ethical issues to consult established and respected frameworks. As lawyers, our ethics are professionalized to legitimize the industry. In regards to this issue, we will look at the Parker and Evans framework, which we endorse at the Dissing O'Connor. The first thing that the Parker and Evans framework suggests we should do is to be aware of the ethical issue that has arisen. The main issue in this situation was with reconciling the conflicting fiduciary duties that we owed to both Lily and Phil. Lily and Phil came to us together. Therefore, the fiduciary duties to avoid conflicts of interest and breaches of confidentiality apply to them both. However, Lily's call to Susan created a conflict of interest such that the firm could no longer act in the best interest of both clients. The firm has a duty to tell Lily to keep her evidence confidential. This means that the firm shouldn't be able to tell Phil about Lily's evidence. Lily's best interest may now also involve pursuing a cutthroat defense, which means that we also have a duty to actively use Lily's evidence for the purposes of this defense. In contrast to all of this, the firm has a duty to Phil not to use his evidence as it is not in his best interests. We also have a duty not to withhold information from him that would be beneficial to his case. What is clear is that the firm can't reconcile the various duties owed to Phil and Lily if they continue to represent both of them. That is to say, the paramount question here is to decide whose retainer to terminate and who to continue representing. Applying the second step of the Parker and Evans decision-making model involves making the choice of who to continue representing. We base this choice on the range of ethical standards and values which are available to us. If we choose to stop representing Lily, we would have a continued retainer with Phil. This means that we would be obliged to tell Phil about Lily's evidence of duress because he would need to know about it so we could serve his best interests. However, revealing this information to Phil would break the rules of confidentiality. Though we no longer have a retainer with Lily, confidentiality is a duty that transcends the termination of the retainer. It would be an ethical breach to tell Phil about Lily's evidence. If we choose to stop representing Phil, he would have to seek alternative legal representation. He would find out about Lily's claim of duress in another way, likely when the evidence is brought before the court. If we choose this option, we would not be in violation of any breaches of confidentiality or any other duties. Since we ought to minimize the extent of any ethical violations, this is the option that we should choose moving forward. The third step of the Parker and Evans model asks us to implement our decisions in practice. We believe that the way Susan and Alex conducted themselves was good, but not perfect. In an ideal world, this situation would have gone as follows. 1. When Susan became aware of the conflict, she would have let Alex and the relevant partners know immediately. 2. Immediately after this, Phil's retainer would have been terminated, as the Chinese wall did not remove the breach of fiduciary loyalty in respect of either client, thinking back to Rule 12.1. And thirdly, Alex should have explained to Phil that the retainer was terminated due to an arising conflict and they could not have further contact about the issue. He should not have called Phil, not offered advice for alternate firms, and not offered potential legal arguments. That is a startling breach of Alex's duty to Lily, whose retainer was not terminated. It would have also potentially led Phil to believe that he had an implied retainer. A hypothetical failure to implement these solutions may have constituted either unsatisfactory professional conduct or professional misconduct. Representing both clients in spite of the violation of the duty of loyalty which would occur through this betrayal of trust would likely amount to professional misconduct, as outlined by Section 297 of the Legal Profession Uniform Law, as referring to conduct in which a substantial failure to reach a reasonable standard of competence took place. A failure to terminate the relationship with one or both of the clients would have demonstrated a failure to fulfill the firm's basic duties of competence and loyalty, as well as being a direct contravention of Solicitors Rules 10 to 12. This contravention would then fall under the Legal Professional Uniform Law, Section 298H, opening the firm and lawyers involved up to potential disciplinary matters. If this attempt to hold both clients were to have occurred, we would have been liable under Section 297 for the finding of professional misconduct, with potential results including the striking off of solicitors involved in the matter and the matter potentially being brought before the OLSC. This issue is of significant importance for the profession as a whole to manage, with our proposed solutions being valuable for all firms to consider. The implementation of a formal process in which any fiduciary relationship with a client is severed following a concurrent conflict should be observed closely through the legal community, so as to avoid this particular issue arising. More generally, as outlined in the Dow Pont Solicitor's Manual, it is prudent as general principle not to take on clients with any potential concurrent conflicts.
Congratulations, you have now successfully completed our module on concurrent conflicts. We hope that you have gained a good understanding of the issues surrounding these conflicts and that you have the relevant legal tools to help you resolve them in the future. It is important to understand that acting ethically is crucial to both reputational and legal protection for a firm and its lawyers. If you are ever in concern about a similar legal issue and need further help, lawyers can also get advice from the Ethics Unit of the New South Wales Law Society, as well as the New South Wales Bar Association. Thank you for your participation, and we will see you in the next module.